Good, all right. Ladies and gentlemen, it's 6 o'clock on Thursday, the 26th of June. I welcome you all to a Board of Adjustment hearing. May we all rise for the Pledge of Allegiance.
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice.
Annie, will you please call the roll?
Board Member Carol Connery. Board Member David Gardella. Board Member Tony Gatliff.
Here.
Board Member Mark Mariano.
Here.
Board Member Gerald Wizawati.
He's coming in on Zoom, isn't he?
Yes, he should be here on Zoom. Kyle, do we have?
I do not show Mr. Wizawati.
Alternate Board Member Matt Dixon.
Here.
Vice Chair Jane Mason Goldman.
Here.
Chair Mike Kelly.
Here.
City Manager Kyle Riefler.
Here.
City Attorney Zoe Rolls.
Here.
Thank you. Our first agenda item is the approval of minutes for October 16, 2024 board meeting. In your packet is page 2 through 18. It's an extensive meeting, extensive minutes. If there's any additions or corrections, now's the time to make them. Otherwise, I'll ask for a motion to approve the agenda. Approve the minutes.
Second.
I'm sorry, who did the second? Thank you.
All in favor of approving the minutes, please say aye.
Aye.
Opposed? Motion carries. At this time, any people that are going to be talking tonight should be sworn in by our city clerk. Anyone, please rise if you're going to speak. I'd appreciate it.
Do you solemnly declare or affirm that the testimony you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth?
Yes, I do.
I want to actually back up a step and welcome our new alternate board member, Matt Dixon. This is Matt's first meeting. He was approved by council at an earlier meeting this month. We're thrilled to have you. We're throwing your right hand on the fire and having you here, our first meeting since we last got together, so welcome. I'm going to go ahead and read the rules of procedure that we follow, both for the board members and for the audience. I will read the variance request, at which point Kyle and the staff of our city will go ahead and make their report. Then we'll ask for the applicant to go ahead and make a statement and give us any information they can about their particular case. After a period of time of open discussion, the board is then designated to go through a series of criteria items that normally are approximately 7 in total, because we're dealing with zoning sections, but because this is a variance regarding our floodplain management section, we have a total tonight of 16 criteria questions. After that period of questions and voting, there will be a motion and a second for approval or denial of the variance request. And our city clerk will do a roll call vote at that time. Any questions at the board to this time? Zoe, when do you want to go ahead and take over and chime in for us?
Actually, that was all that I wanted to say. I was just going to say exactly what you said, just to clarify that the original agenda had incorrectly listed the Chapter 94 as the criteria that you would consider, but as you just mentioned, the criteria actually come from Chapter 74, and so that was all I was going to add. So thank you.
Thank you for the confirmation. Appreciate it. At this time, I'd like to ask Kyle, our city manager, to go ahead and make a staff report.
Thank you, Kyle Riefler, City Manager, Bella Beach. For tonight's hearing, we hired Luis Serna. He's a certified planner. He does contractual work for the city, and he's prepared a staff report to present to you currently. So he's got a full report. He should have been included in your packet, and I'd like to introduce Mr. Luis Serna.
Just before Mr. Cerny, come on up, but just before he comes up, I want to read the actual variance. The purpose of this variance is to allow a variance of 42 inches from the required elevation of BFE AE9 plus 1 foot on all HVAC condensers specified in the 2023 Florida Building Code. Primarily, we're dealing with a multifamily project. It's Tortugas de Mar over on Gulf Boulevard at 2500 Gulf Boulevard in our RM1 zone. Mr. Cerna, the floor is yours.
Yes, good evening, Chairman and board members. Luis Cerna presenting staff comments. This request would allow the replacement of HVAC equipment at the Tortugas Del Mar condominiums to be located at the ground level where the existing compressors are currently located. The Florida Building Code and the city's floodplain management regulations require that new or replacement mechanical equipment be elevated to the BFE plus 1 foot, which is an elevation of 42 inches above existing grade. The applicants have indicated that the variance is necessary to prevent the equipment from blocking views from the first floor windows and to allow the units to continue to be screened by hedges from Gulf Boulevard. So I've gone through the applicable criteria of the code to help guide you in your decision making and discussions. The board will ultimately discuss the criteria and make a determination whether or not these criteria are met. But I'd like to just go through the criteria and my findings, and I'll focus on the findings that, in my opinion, the application does not meet. So, starting with section 74-117, this is from the floodplain management regulations. The first criteria is...
Mr. Cerna,
yes.
for the help of the board members, you're reading from your report approximately page 3 of 8.
Page 3, yes, correct. Starting with paragraph 1, yes.
Oh, you got it? Good?
Yes, so the first criteria is the danger that the materials and debris may be swept into other lands, resulting in further injury or damage. We have found that this application meets that criteria. The second is a danger to life and property due to flooding or erosion and damage. The finding is that the damage resulting from this variance would be limited to the HVAC equipment on the subject property. The third criteria is the susceptibility of the proposed development, including contents to flood damage and the effects of such damage on current and future owners. The finding is that the variance would result in risk of damage to HVAC equipment to current and future owners of the subject property from flooding. The fourth criteria is the importance of the services provided by the proposed development to the community. We find that the application meets that criteria. Number 5, starting on page 4, the availability of alternate locations for the proposed development that are subject to lower risk of flooding or erosion. Our finding on this one is that the applicants have not demonstrated that alternate locations are not available for the HVAC equipment that would not affect visibility of the HVAC equipment from first floor windows or the road. Number 6, the compatibility of the proposed development with existing and anticipated development. We find that it meets this criteria. Number 7, the relationship of the proposed development to the comprehensive plan and floodplain management program for the area. The finding is that the proposed development requests a variance from the city's floodplain management regulations. Such variance requests are permitted under the city's floodplain management regulations, and are consistent with the comprehensive plan, so this criteria is met. Number 8, the safety of access to the property in times of flooding for ordinary and emergency vehicles. This criterion is met by the application. The expected heights, velocity, duration, rate of rise and debris, and sediment transport of the floodwaters, and the effect of wave action, if applicable, expected on the site. This application is not, this property is not in a V or coastal A zone, so this is not a concern, and we find this criterion is met. The cost of providing government services during and after flood conditions, including maintenance and repair of public utilities and facilities such as sewer, gas, electrical, water systems, streets, and bridges. This criterion is in our opinion is met. Okay, then jumping over to page 5 of 8, this is section 14-118, conditions for issuance of variances. And I'll go through these. Number 1 is the submission by the applicant of a showing of good and sufficient cause that unique characteristics of the size, configuration, or topography of the site limit compliance with any provision of this chapter or the required flood elevation standards. The finding in regard to this criterion is the variance request is not due to unique characteristics of the site. Number 2, determination by the Board of Adjustment that A, failure to grant the variance would result in exceptional hardship due to the physical characteristics of the land that render the lot undevelopable, increased cost to satisfy the requirements, or inconvenience do not constitute a hardship. So our finding in regard to this criterion is that the applicants have not demonstrated that an exceptional hardship that would render the lot undevelopable would result by failure to grant the variance. B, the granting of the variance would not result in increased flood heights, additional threats to public safety, extraordinary public expense, nor create nuisances, cause fraud on or victimization of the public, or conflict with the existing local laws and chapters. Our finding is that the applicant meets this criteria. C, the variance is the minimum necessary considering the flood hazard to afford relief. Our finding is the applicants have not demonstrated that this variance is the minimum necessary to afford relief. The applicants should demonstrate that alternate locations and or heights are available to address the potential visibility concerns with increasing the heights of the HVAC equipment. On page 6, it's number 3, it's misnumbered as 2. Their receipt of a signed statement by the applicant that the variance, if granted, shall be recorded in the office of the clerk of the court in such a manner that it appears in the chain of title of the affected parcel or land. We've recommended this. If approval is granted, this be required as a condition of approval. The next one, number 4, if the request is for a variance to allow construction of the lowest floor of a new building, this criterion is not applicable to this request. And then jumping to chapter 94, more criterion, variances and appeals that under the powers and duties of the Board of Adjustment. Section 94-62 states the criterion there. I'll jump to page 7. Number 1, demonstrated that special conditions or unique circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to other similar structures or buildings in the same zoning district. The finding is that the applicants have not demonstrated that conflict between the elevations of the HVAC equipment and the first floor windows are unique to the subject property. Number 2, demonstrated that the variance request is the minimum variance that will make possible the reasonable use of the land, building, or structure. The finding here is that the applicants have not demonstrated that the variance request is the minimum necessary to make possible the reasonable use of the land, building, or structures. Number 3, demonstrate that granting the variance request will not confer on the applicant any special privilege that is denied by this chapter. The finding is that the criterion will not confer on the applicant any special privilege that is denied by the zoning section of the Land Development Code. Number 4, demonstrate that the variance request does not change the use of the property from the use characteristics mandated for Districts 1 and 2 in sections 30-51 and 94-252 of Article 4, Division 3 of this chapter. This criterion is met, in our opinion. Number 5, will fully comply with additional conditions, safeguards, which the Board of Adjustments may prescribe, including but not limited to reasonable time limits within which the action for which a variance is required shall commence and or be completed. The finding is that the applicant will be subject to any conditions if the Board of Adjustment votes to grant approval of this. Number 6, demonstrate that the variance request does not violate any provision and requirements set forth in Chapter 62 and Chapter 74 of this code. The proposed variance would permit the HVAC equipment to be located below the minimum flood elevations of Chapter 74. The variance would not violate any other provisions of Chapter 62 utilities and Chapter 74 floodplain management of the city's code. And finally, number 7, such variance is not in conflict with the City of Bel Air Beach strategic plan. There is no conflict, in our opinion, with the strategic plan. In conclusion, based on the review of the criterion that I met, and specifically the ones that this application does not meet, and I'll mention demonstrating that the variance is a minimum necessary, alternate locations are not available, and the request is not the result of unique conditions or characteristics, and that an exceptional hardship would not result, we're recommending denial of this application. And we've recommended a condition of approval should the board decide to vote to approve this. So I'd be glad to answer any of your questions in regard to my findings.
Board members, any questions for Mr. Sermon?
So I have a question. So if this property is not in the B or the A, what properties in the city are?
There are properties that are closer to the water that, are subject to the velocity zone and the coastal A zone standards. So, there are properties.
Yeah, we have A properties, we just, this is not a coastal A property, so it's not within that 3-foot limit law.
Okay. So I think it's split, by the way, with the BE and the AE and the floodplain maps, right? So it's in the velocity zone on that floodplain map. And then I guess another question, maybe not for the consultant, but maybe, what liability does the city take on if we were to grant this below the base flood elevation and something were to happen in a flooding event to all of the HVAC units, and we approved the reduced height?
Yeah, I'll look to the attorney to perhaps answer that question.
I don't have a formal opinion as to liability at this time, but I mean, it's something that we could look into should the board wish to move forward with variance. And I apologize, while I do have a moment, I just want to also clarify that while we did hear the analysis regarding Chapter 94, I did just want to clarify one more time that the analysis should be limited to those factors in Chapter 74.
I have one question, and maybe I missed it, but is our city code in conflict with the Florida Building Code related to this?
No, it's not. The city code refers to the Florida Building Code and requires compliance with that.
Okay, so we're saying that the air conditioning units have to be within the Florida Building Code and our city code, and the reason for your denial is because this request is not in compliance with that.
Correct. Yeah, that's a reason for the variance request.
Okay, just want to make sure I understood. Thank you.
Tony, David?
Well, I have questions for the other part of the applicant, yes.
Okay. Mr. Cerna, thank you very much. Anybody in the audience with any questions, you're more than welcome. Mr. Cerna, you're here for their help too, so if
I'll
not,
take
I'd
one.
like the applicant to come forward and feel free to make your presentation.
Thank you, Board. I'm Dave Kahn. I'm on the Board of Directors at Tortugas and Mar, and representing our association requesting this variance. That was a lot of stuff for an air conditioner variance, none of which we knew was required when we made our application, so I'm going to deal with it in front of you all right now for the first time. I think in summary, the recommendation to deny was based on the fact that we didn't demonstrate that we couldn't have another height other than 42 inches. We just said we want it where it is. And number two, we didn't demonstrate there might be another location within the property we can move it to. And number three, it makes no sense to me at all since we're not developing anything. So the undeveloped part, I don't know. I'll have to ask again, I'm not sure what that's about. This project was built in 1975 by a guy named Jim Burt over in Tampa, whose son I know very well. Our electric room is underground. Our elevator room, mechanical room is underground. The city or the county granted us permits to reinstate both of those things. So we were without power for roughly 7 months. We just got power back. So 30 units didn't have power because our underground elevator room, and more importantly, the electrical room, was totally flooded. So it seems odd to me that they granted us a permit to reinstate that, but we're fighting about an air conditioning variance right here where many of our air conditioners, despite this 100-year event, are still working. We are getting money from FEMA to replace the condensers out front. The new systems now have new Freon, so there's an opportunity for some residents to replace their units outside, replace their air handlers inside, and take that money and do that right now. Unfortunately, you adopted this building code, which requires them to be 48 inches. On the screen are some pictures of Tortugas before the storm. Unfortunately, I don't have a pointer. I don't know if you can see or not, but we have 30 units in our complex, 2 buildings, 15 each, 5 on the bottom floor. And at that hedgerow at the bottom, and I'm moving my cursor around a little bit right now, behind those hedges are where the air conditioning, 6 air conditioning units are located on that wall. As you turn the corner, 6 are on this wall. And then in the back, which I'll show you, we have 3 and 3 on the back. So right now they're screened by the hedges. You can't see them, as you can see, as I'm going to show you. It's a very nice project, or it was a nice project. Right in this back corner right here is where the other 3 units are for each building. You can see back here, this is 3 units that are screened by a wall on both sides. Again, very tasteful below the windows. This is just a little picture. This wall I'm going to show you later. This would be the only place we could probably relocate them to. And I'll show you why I don't think that works. And this is a shot from the back. Hard to believe it's not a velocity zone, I agree. This is post-storm. You can see 1 unit to the far left has been replaced. And you can see how high that is. That meets current code. So that's standing out like a small building to the left. There's 5 other units that haven't been replaced yet that run right around in front of those windows. So you can see just looking at that, the height of that unit goes almost to the top of the windows.
Mr. Khan, we've got a couple photographs. Maybe these are blow-ups of what you're describing. Is that correct?
Some of them are, some of them aren't. I took some more. When I found out about all these other things, I took some more pictures. So those are, some of them are in here, and I've added some more too.
So that was one of the ones that you just referred to.
It could be, I don't know.
But it shows, these are raised, the 1 unit is raised up, so this is in compliance.
That is in compliance, yes.
Okay, thank you.
So just, to address Louis' comments, I measured today, the height of from the floor ground to the bottom of our windows are 40, I measured 46 inches. Granted, there's still some sand in there. 46 seems like an odd number, so it might be 48 inches from ground up to the bottom of the window. Those stands have to be 48 inches. So the stand would be at the bottom of the window, and the average unit height that I've measured out there are anywhere from 70 to 80 inches. So basically, there's no way to screen those things without totally hiding the first floor windows.
You talked about alternate locations that you don't think will work. Can you explain that?
Yes. The picture you see right now are various units. If you remember, I showed you that back corner of the screen wall. That's where they each, those 3 units have been raised. You can see that one is totally blocked there. It's also now exposed to the elements, which is another issue that we'll talk about. Where they currently are located, either the screen hidden from the elements or our buildings hidden. So the front of the buildings kind of protected them from the elements. If we move into this alternative location, you can see some more pictures of the defensive nature of these raised units that have been installed already. So here's the wall. So this would be the south wall facing Las Caras Close. So the unit heights are the same. The height under those middle windows are bathroom windows. The height of those is 59 inches. These windows' heights are 46 inches. There's a water spigot and hose right there. I think we could probably stick one here, possibly 2, 1, 2, 3, 4, maybe 5 units. I would still mean we couldn't do all 6 units. We'd still have to screen them, in my opinion. There's a public access point, which I'll show you from an aerial, that allows access from the community to the beach. And you're walking by and you can see these units as we Caracoles, our neighbors. This is a view from one of our residents from a window, from this window right here. So even if we put a unit here, which technically wouldn't block a straight out view, you can see looking at the water, that unit, which is anywhere from $30 to $34 inches wide plus a foot off the building. You can see that basically this entire area here would be blocked from review. Also, the beach is to the left of the screen, so these would be wide open to the elements, whereas in the front they wouldn't be. So, could we move them there? Yes. Actually, we couldn't move them all there. We'd still have to keep 1 or 2 in front. The cost to move them, according to an air conditioning guy I talked to, would be a minimum of $1,500 to $2,000. The stands themselves are $750 plus the cost of the AC units on top of that. So it's not cheap either. Again, the building height of the windows is 42 inches, 46 inches. So we already have pads of about 1 foot out there now. So we're at about 8.5 feet right now. Base flood is, I think, 10. So there's really no room to add anything. I mean, what Louis was saying was, well, if 48 doesn't work, would 42 work, or would 36 work? My answer is no. It's kind of an all or nothing thing for me. It's
How many of these units did you lose during the storm? All?
No. In fact, I would say it's hard to say because some people elected to replace them even though their units work. My unit still works. So I don't know if did yours work or not?
Mine was on the corner stock.
So it didn't work. Okay. Yours worked? Yeah. So I would say if we have 30 units, I'm going to guess 20s are still working, maybe 25. But some people elected to replace them, some people had to replace them. But either way, at some point, you can't replace them now with the existing units that you had before because of the freon changes. So whether it's this year, next year, my unit works, but salt water got into it. Is the lifespan of my unit going to be 1 year, 2 years? I don't know, but at some point we're going to have to replace them. So we don't want forcefully installed units detracting from the beauty of our complex. You'll be able to see them from Gulf Boulevard. Even if we move them around the side, you'll still be able to see down the side of them. You won't see 6 of them, you'll see the big one out front. I just don't see how you screen them effectively. I don't think it does what, I don't think it's an option, a viable option, which would take care of one of those objections. I don't think the height, we have any room on the height that we're talking about. which would be the other objection. And again, I don't know what the whole developable thing is. We're not developing anything. If this is new development, that wouldn't be here. We'd be meeting all the codes.
So some of the units were already raised, correct?
Yeah, so if you grant the variance, the board will probably, I don't know, but my motion board will pay to lower them back down. So $750 have gone down the tubes. We really weren't in a position to tell people not to hook up new air conditioners because they've been out of use for 7 months. So kind of like do what you got to do, and then we'll come back and deal with it if we're successful with this variance.
You know how many units need to be raised for the county?
All of them would have to be raised if they were all to be replaced.
Outside of the ones that are already raised, how many are not raised at this point?
I should have counted.
27
27 still need.
Yeah, wait.
No, there's more than that that were raised.
that haven't been raised.
I think it's less than that. My guess is there's been 12 or 13 that have been raised, so minus 30, probably 17 yet that would have to be raised.
Marcy, you
We're
want to ask
saying more.
Mr. Khan that question again? This is a good time.
Relative to liability?
Yeah.
Yeah, so the liability, we would, it's on us, right? It's not you. We just had a big storm. It's our insurance, it's our risk. We're not putting the community at risk. We're not putting you at risk financially. There's no liability.
I know,
So it's
what I fear is not you, your insurance provider comes back and says, well, city, you allowed them to be 42 inches under base flood elevation. Why should we step in and pay for this if you allow the reduction in height? I don't know the answer to that, to be honest. From a legal perspective, I don't know the
It's
answer.
our insurance policy, not your policy. It's
No,
our-
I
it's
know,
our
but
risk.
it's just like a car accident where you don't want to sue someone, the insurance provider steps in and does it regardless, they have the right to do it.
How would that be a liability for the?
But if they come back to the city and say, you allowed them to be under base flood elevation, so join in the party of paying for this.
All I can tell you is Treasure Island is like 31 inches, Reddington Beach is different, Reddington Shores is different, so not everybody's adopted the Florida Building Code. You're allowed to set whatever you want. You chose to use the Florida Building Code, you weren't required to.
I can add it, from what I know currently, as I understand it, public officials acting within their lawful quasi-judicial authority would enjoy a certain immunity as long as you're acting within the scope of your
Yeah,
lawful
I
functions.
understand, we would. I'm just looking out for the city's interest. As part of this, did you have any electric, like the automatic shut-off that had to be installed with the condenser units, or was it?
Yes, actually, FEMA reimbursed us for the disconnects, but I think they all work. Yeah, I think all the disconnects work.
Are those being required to be outside of the base flood elevation?
No.
10 feet up? Very strange.
Like I say, this is hopefully a 100-year event, and the first floor units only had a couple of inches on them. Most of our units are working. I think the wind, I think the second storm is probably what knocked Cindy's over. So hopefully this won't happen again, but if it does, it's our risk. We're willing to take it. Like I said, they permitted an underground electrical room, which is, if they didn't do that, I could understand that, but they did. And we're trying to take precautions to mitigate any flooding from that again.
So you're basically here on behalf of the association with your attendees saying that as a whole, you'd like to be able to maintain the current location of those condensers at the lower level so that it does not obstruct the view of the first floor elevation windows.
Yeah, it's an aesthetic thing for sure. It's both for the first floor residents so they can maintain the views, and it's for the aesthetic of the entire complex. Your city actually has a condition that they can't be visible from Gulf Boulevard, so there's somewhat of a conflict between what the flood requires and what the city requires from an aesthetic standpoint. So theoretically, we're not allowed to have them visible from Gulf Boulevard, if I remember correctly. So, one way or the other, we're going to be.
I would guess without the screening, but here's an
Yeah,
interesting.
it's with the screening, which we
Here's, so, what happens if a shed gets knocked down, but the slab's still there? they allowed to rebuild in the shed, in the existing location? 'Cause and this is interesting from the perspective of, it's a replacement in kind. But the replacement obviously is not in conformance with code. But they're just replacing the unit in kind. It almost makes me think of if a structure was damaged and the majority of the structure remained, you'd be able to replace it in its prior existence.
I'm in commercial real estate, I can tell you that usually the rule is if you don't break 50%, you can replace what you.
I am too. It's why I'm trying to, think of how.
So you're applying a code that's really meant for new development, kind of, I don't say willy-nilly, but it's kind of odd that you're requiring it.
I'm torn on this, because you have the ability, to raise it. It's very aesthetically unpleasing. I agree with what you're saying. But at the same time, I don't want to put undue liability on the city, but it's a replacement in kind of an existing structure that's operated for the entire lifespan of the building.
I don't think there's any liability on the city. I think Butchie answered that for you.
Well, it's not a liability for them.
Is there something we can do, a document that can be created? This is really a legal question. Is there a document that we can have, or they can produce to protect the city? Indemnify us from lawsuits in the future? Is that possible?
That may be possible, and that could perhaps be a condition to the approval, should the board wish to proceed that way.
Mr. Serna, didn't you make a comment about that in your report? Something about if the board granted the variance, that you would insist that the clerks, that something in the filing with the clerk of the courts, that these units would be at the lower elevation?
Yeah, that would be a notification to, current and future owners. So anyone who purchases a unit would be aware that a variance was granted for the AC unit. So that's to protect the future owners.
Zoe, is that something similar to indemnification?
No,
No,
really,
it's just to reflect that the variance exists.
Okay.
The variance.
Basically, the variance just runs with the land, so
Okay.
it would be out there for the next person too. So did I answer your question, Louis, your objections?
Yeah, I think so. I definitely got more information.
Okay.
Would that be something your board would consider, your owners, indemnifying the city?
Well, like I said, I don't think it's necessary. I mean, if Zoe thinks it is, we can talk about it. I don't think it's necessary. We have an insurance policy with FEMA. There's no carve-outs, there's no conditions in that. We just renewed the policy. There's no mention of anything like that. But I can certainly bring it to our board's attention and our attorney's attention. But I don't think you need it. Certainly willing to entertain it.
Yeah, I would say, being in real estate development, I wish it wasn't, but in the litigious nature that we work in, especially in real estate, everything.
Has FEMA come to you for anything? We just had a monster storm. Does FEMA come and ask you guys for anything?
Not that I'm aware of, but maybe a variance granted under base flood elevation, not FEMA, but
Like I said,
insurance provider, right?
There's 3 or 4 other beach communities that are requiring it.
How many markets, how many stories have we heard that people, their insurance provider says, no, we're not paying for this? It's not uncommon. I mean, that's
our risk.
That's a risk for the owner.
That's for us, right, exactly.
Again, I don't know the answer. But valid question.
Any more questions, any more comments by the board or anyone in the audience? You're dealing with an interesting situation, ma'am, come on up. Have you been sworn in? Kathy, she's right behind you.
I did, and you saw me
Please state your name and address.
My name is Cindy Peters, and I live at 2500 Gulf Boulevard, Unit 105A.
Thank you.
So basically, I've been a resident of Bel Air Beach since 1986. And I was actually on city council in the 90s, fought for the beach, and we have not been flooded like this ever, ever. And I know it was a once in a 100-year storm, or what, so they say, but one of the problems that we did have was that the county built a big sand dune out there. And when they built that sand dune and the storm came through, it clogged up all the county drains, which our parking lot drains into. The water, I've never seen it come through my front door, but it came through my front door. So I feel like this variance that we're asking for should not be denied in the sense that it's not hurting anything. My air conditioner was on the corner, it's the one you saw, it sticks up like the Eiffel Tower. And it was knocked over, I think more from the wind than from the waves. So it was on, like I said, it was on the corner. If we had to build a wall or something to protect it, maybe that would have helped. But all the other air conditioners stayed where they were. Many of them work. I think that we've found about 4 that have been replaced. And a lot of them worked, but the people said, well, we're just going to replace them because the change of the Freon, and they didn't want to deal with that. So I just feel like it's something that you can't say will never happen again, but I remember my mother-in-law, who was she was 94 years old when she died. She remembers the storm in Tampa, 1926, I believe. And so it was one of those storms that, it was before that, 1919. But it was a storm that flooded the whole southern point of Tampa. This was probably going to be a storm like that, and I just feel like this is not harming anyone. It's actually harming, if we have to look at it, it harms me. I can't look out my window. I can't see if somebody's coming in, or I'm going to request that you grant our variance. Thank you for listening.
Thank you very much.
Oh, and one other thing.
Come on back.
One other thing. It does state in that it's if for new, what was the laws? For new air conditioners, it had to be 42 inches. It didn't state anything about replacement in that.
Okay. So this was brought to your attention by a Pinellas County building inspector?
Yes.
Okay.
It was actually the air conditioning company going to pull permits. They didn't even know about it. And in fact, they've been replacing, this code passed, was adopted in 2023. They've been replacing air conditioning units for the last 2 years at their current levels. It's only recently that the county started enforcing this, so, or whatever. You talk about liability. I would think our electrical room is way more liability than these air conditioning units. If he wants to sign off on the absolving you of any responsibility, glad to do it.
No, we're not granting variance for your electric.
No, we're not, but I'm just saying. If you want to make that a condition, I'd be fine with that. I think we've addressed all his reasons for not granting the variance, unless I'm mistaken, so hopefully we give him sufficient reason to grant.
Okay, at this point, this is where we, the board, go back to the criteria listed. There's a series of questions, which I think are as many as, what, 16 tonight? Mr. Cerner read his answers to the original 10, plus there's another 6. So we will go over them one at a time. We will vote on them one at a time. At this point, I'll turn the meeting over to Vice Chairman Goldman, and she will go through these 3 pages, board, of worksheets that you have.
Mike, one question. On them offering to indemnify the city
Kyle.
as a
Jerry
condition.
didn't
Sure.
join.
How do we work that
We
in?
had that,
Mr. Pizzolotti didn't join.
when the actual series of criteria are already read and a motion is made, we add that to the motion. It's a stipulation to the motion. Okay.
Okay, everybody ready? This is gonna be long. Okay, we have to go through each one, right?
Kathy, you gotta call the roll on each one?
I'm sorry.
That's okay.
No, you're fine.
As soon as we go through each one, we'll ask you to call. the roll.
Yes.
Terrific.
Mm-hmm.
Okay.
Got it.
Okay. For today's meeting, we're going to go over the considerations for issuance of a variance under section 74.117. The first one, did the applicant show that the danger that materials and debris may be slept onto other lands resulting in further injury or damage? You say yes, the variance is approved, no, the variance is denied.
Kathy?
Mr. Gatliff,
Yes.
Mr. Dixon,
Yes.
Mr. Gardella,
Yes.
Mr. Mariano,
Yes.
Ms. Goldman,
Yes.
Mr. Kelly.
Yes. 6-0? Okay.
Number 2, the danger to life and property due to flooding or erosion damage. Has the applicant proved that that's not the case? Yes, is variance approved? No, is variance denied?
Mr. Gatliff,
Yes.
Mr. Dixon,
Yes.
Mr. Gardella,
Yes.
Mr. Mariano,
Yes.
Ms. Goldman,
Yes.
Mr. Kelly.
Yes.
6-0.
Okay, number 3, the susceptibility of the proposed development, including contents to flood damage and the effect of such damage on current and future owners. Yes, the variance is approved. No, variance is denied.
Mr. Gatliff,
No.
Mr. Dixon,
No.
Mr. Gardella,
No.
Mr. Mariano,
No.
Ms. Goldman,
No.
Mr. Kelly.
No.
Number 4, the importance of the services provided by the proposed development to the community. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff,
Yes.
Mr. Dixon,
Yes.
Mr. Gardella,
Yes.
Mr. Mariano,
Yes.
Ms. Goldman,
Yes.
Mr. Kelly.
Yes.
Number 5, the availability of alternate locations for the proposed development that are subject to the lower risk of flooding or erosion. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff,
Yes.
Mr. Dixon,
No.
Mr. Gardella,
Yes.
Mr. Mariano,
No.
Ms. Goldman,
No.
Mr. Kelly.
No.
Number 6, the compatibility of the proposed development with existing and anticipated development. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff,
Yes.
Mr. Dixon,
Yes.
Mr. Gardella,
No.
Mr. Mariano,
No.
Ms. Goldman,
No.
Mr. Kelly.
No.
Number 7, the relationship of the proposed development to the comprehensive plan and floodplain management program for the area. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff,
Yes.
Mr. Dixon,
Yes.
Mr. Gardella,
Yes.
Mr. Mariano,
Yes.
Ms. Goldman,
Yes.
and Mr. Kelly.
Yes.
Number 8, the safety of access to the property in times of flooding for ordinary and emergency vehicles. Yes, variance is approved, no, variance is denied.
Mr. Gatliff?
Yes.
Mr. Dixon?
Yes.
Mr. Gardella?
Yes.
Mr. Mariano?
Yes.
Ms. Goldman?
Yes.
Mr. Kelly?
Yes.
Number 9, the expected heights, velocity, duration, rate of rise, and debris and sediment transport of the floodwaters and the effects of the wave action, if applicable, expected at the site. Yes, the variance is approved, and no, the variance is denied.
Mr. Gatliff?
Yes.
Mr. Dixon?
Yes.
Mr. Gardella?
Yes.
Mr. Mariano?
Yes.
Ms. Goldman?
Yes.
Mr. Kelly?
Yes.
Number 10, the cost of providing governmental services during and after flooding conditions, including maintenance and repair of public utilities and facilities such as sewer, gas, electrical, and water systems, streets, and bridges.
Mr. Gatliff?
Yes.
Mr. Dixon?
Yes.
Mr. Gardella?
Yes.
Mr. Mariano?
Yes.
Ms. Goldman?
Yes.
Mr. Kelly?
Yes.
Okay, we're moving to the next section, which is 74.118, and it's conditions for issuance of the variances. The variances shall be issued only upon, number 1, submission by the applicant of a showing of good and sufficient cause that the unique characteristics of the size, configuration, or topography of the site limit compliance with any provision of this chapter or the required elevation standard.
Mr. Gatliff?
Yes.
Mr. Dixon?
No.
Mr. Gardella?
Yes.
Mr. Mariano?
No.
And Ms. Goldman?
Yes.
Mr. Kelly?
Yes.
Okay, number 2, failure to grant the variance would result in exceptional hardship due to the physical characteristics of the land that would render the lot undevelopable, increased costs to satisfy the requirements or inconvenience do not constitute hardship. Increased costs to satisfy the requirements or inconvenience do not constitute hardship. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff?
No.
Mr. Dixon?
No.
Mr. Gardella?
No.
Mr. Mariano?
No.
Ms. Goldman?
No.
Mr. Kelly?
No.
Okay, 2B, the granting of a variance will not result in increased flood heights, additional threats to public safety, extraordinary public expense, nor create nuisances, cause fraud on or victimization of the public, or conflict with existing local laws and chapters. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff?
Yes.
Mr. Dixon?
Yes.
Mr. Gardella?
Yes.
Mr. Mariano?
Yes.
Ms. Goldman?
Yes.
And Mr. Kelly?
Yes.
Okay, 2C, the variance is the minimum necessary considering the flood hazard to afford relief. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff?
Yes.
Mr. Dixon?
No.
Mr. Gardella?
Yes.
Mr. Mariano?
No.
Ms. Goldman?
Yes.
Mr. Kelly?
Yes.
Okay, 3, receipt of a signed statement by the applicant that the variance, if granted, should be recorded in the office of the clerk of the court in such a manner that it appears in the chain of title of the affected parcel of land. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff?
Yes.
Mr. Dixon?
Yes.
Mr. Gardella?
Yes.
Mr. Mariano?
Yes.
Ms. Goldman?
Yes.
Mr. Kelly.
Yes.
Okay, number 4, we're almost there. If the request is a variance to allow construction of the lowest floor of a new building or substantial improvement of a building below the required elevation, a copy in the record of a written notice from the floodplain administrator to the applicant for the variance, specifying the difference between the base flood elevation and the proposed elevation of the lowest floor, stating that the cost of federal flood insurance will not be commensurate with the increased risk resulting from the reduced floor elevation, up to amounts as high as $25 or $100 of insurance coverage, and stating that construction below the base flood elevation increases risk to life and property. Yes, the variance is approved. No, the variance is denied.
Mr. Gatliff.
Yes.
Mr. Dixon.
Yes.
Mr. Gardella.
Yes.
Mr. Mariano.
Yes.
Ms. Goldman.
Yes.
Mr. Kelly.
Yes. Okay, you're keeping tabs. I think we had 2 or 3 no's in a total of 16. For the record, in one of the application criteria, one of the requirements, when you apply for a variance, it says in the instructions, if the board determines that any one of your answers to the 6 individual questions, in this case we had 16, listed in the application is insufficient in nature and reason to earn a yes vote by a majority of the members that are present at the meeting, your variance request will be denied. At this point, Kathy, you've got, what, 3 or 4 no votes? I will ask the board if anyone would like to make a motion regarding variance number 25-01.
Make a motion that we approve it.
Is there a second?
Can we add a condition?
We should, no matter what happens.
I'll second with the condition that the city does not take on any undue liability from granting the variance.
Will the motion maker accept that?
Yes, absolutely.
Okay, so we have a motion and a second for approval of the variance. My own personal comment is that we've heard a lot tonight. These people didn't ask for it. It's a situation where we, as a body, are going to do the best we can. Yes, we've heard 16 rather than 6 criteria that we normally do, because we're not dealing with zoning questions. We're dealing with floodplain questions. It's a first for this board. It's a unique condition, to be sure. The circumstances and the hardship are bona fide, and your motion is valid. So, Kathy, I'd like to go ahead and ask you to hold the board regarding the motion. So a yes vote is for approval, a no vote is denied.
Mr. Gatliff.
Yes.
Mr. Dixon.
Yes.
Mr. Gardella.
Yes.
Mr. Mariano.
Yes.
Ms. Goldman.
Yes.
Mr. Kelly.
Yes. Mr. Khan, your motion is approved. The variance is approved, excuse me.
Thank you very much. And one thing regarding your addendum, would Zoe be reaching out to us for something, or would you want us to do something, or, because we don't need anything?
We'll reach out.
Okay.
This
Thank you
is
for your time.
approved with the condition.
Okay, much appreciated, thanks very much.
Are there any other items to come before the board at this time? We'll be glad to discuss them. Matt, I'm going to welcome you again. You did a good job tonight with the rest of our workers and members, and we wish to see you in the future. Any other comments? Now I'll entertain a motion to adjourn.
Can
Thanks, everybody. We stand adjourned.